This is a quick tutorial on the 90-day trial period and how it applies to employees and how employers can get it right. So let's just talk very quickly about removing some confusion. The 90-day trial period is not a hiring process, it is a firing process. It enables the employer, if done correctly, to terminate the employment relationship during the first 90 days. The trial period can't be extended, it can't be for 91 days, you can't sign a trial period beyond that period of 90 days. So let's just clarify that. Second, it can be terminated at any time from the first day to the 89th day, and from an employer's perspective, that needs to be done correctly to make sure that the trial period is valid. There are some very, very strict rules around how an employer must comply with the Act to ensure that it is done correctly. So we'll just talk through those very quickly. One, the trial period must be in writing. Two, it must be contained within the employment agreement. The trial period must specify that you are giving up your right to raise a personal grievance for an unjustified dismissal. Third, and of course next, very importantly, is that the trial period must be agreed before the employment commences. So if the employer provides you an employment agreement on the second day, third day, or the first day of your employment, and you sign it and it has a trial period in it, it's not valid and the termination of employment would be unjustified and you would have a very good case to proceed. Of course, the employer has an obligation to bargain with you regarding any terms and conditions, so trial periods are not compulsory. They do not need to be in an employment agreement and they must be agreed. So if you don't want the 90-day trial period in there, prior to your commencement, you are entitled to say, can I please have this removed? That is an absolute entitlement that you have. The termination of employment is generally for employees who are not suitable. So the normal processes around poor performance, the issuing of warnings, bullying, harassment, of any other type of nature, misconduct, those issues would need to be dealt with in the normal manner. So if the employer believes that you've done something wrong or inappropriate or poorly performing, they still must conduct a proper investigation and process for issuing warnings. The Act does not prohibit you from taking a personal grievance for an unjustified disadvantage, for some form of breach of good faith, breach of the employment agreement, or an inappropriate process for issuing warnings. So the normal laws apply around everything but the unjustified dismissal only. The employer is not required to go down a process. The employer is not required to go down a procedural path if the trial period is valid and complies with the law. Because it is a technical issue, I strongly would recommend that you allow us to review the employment agreement either prior to commencement or if you have been terminated under reliance on the 90-day trial period. We'll have a look at it and for you, and we'll be able to tell you very quickly whether or not the 90-day trial period is valid and whether or not you have a good case for an unjustified dismissal. If you're an employer, please contact me. Make sure your employment agreements comply with the law and make sure that they are handed out in a correct manner. What I would say is that a reasonable period of time should be given to the employee to get legal advice, bargain on the terms and conditions of that employment agreement, and come back to you with any changes that they may want. I think that's covered off most of the very basic issues. There are of course some very legal issues that would need to be considered, and again, call us first. You can count on us to make sure that you get the right advice at the right time. Thanks.